So we definitely have an experienced group of folks to talk with you about today. And so what are we going to talk about? Here's the agenda. Who are the caregivers? So just in case you don't know, we're going to describe for you the caregivers that we're going to be talking about. We'll talk a little bit about the challenges that caregivers face on a daily, weekly, monthly basis. And then we're going to get into the meat of the presentation and talk about some legal fundamentals of caregiving. And then finally, I'm going to have a variety of additional resources that are available to you. And so just so that you know, um, during this presentation, I welcome you to drop some questions into the Q&A or the chat. Time permitting, we will address those questions. We really want to know what you want to know about, and we will do our best to answer your questions to the extent that we're able. Please also know that we are going to send you some follow-on materials after the conclusion of the presentation that will include a lot of the additional resources that I'll be making reference to. You also have an opportunity, if you would like, to schedule an appointment with one of us to talk about whatever it is that you want to talk about. And we will provide you with a link where you can self-schedule an appointment with a member of my team, including me or Kevin. So who are the caregivers? You are a caregiver. If at any time in the last year you have provided unpaid help, or maybe even paid help if you're for a family caregiver, we're going to talk about that a little bit later, or arranged for help for a relative or a friend who is unable to do some things for themselves as a result of either an illness or age or disability, any one of those things, you are a caregiver. And the kind of help that you typically would be providing would be assistance with sort of normal daily living, like household chores. Perhaps you're assisting with finances. Maybe you're helping with personal or medical needs, bathing, grocery shopping, taking somebody to doctor's appointments, taking them to the bank, running errands, shopping for them. You know, all of those things fall into the category of the types of things that caregivers do. And it might be that the person that you're assisting, the care recipient, lives in their own home and you go to see them there. Or maybe they actually live with you in your own home and you're providing care with them. Or they've got a different place that they live, such as an assisted living facility or an independent living facility or even a nursing home. They can be just about anywhere that you're providing them with care. And so here are just a few key facts about caregivers. 42 million Americans are caregivers to an adult, a person who is aged 50 or over. That's a huge portion of the US population. There are so many caregivers out there. And with the age wave that we have coming with all the baby boomers, it's only going to get larger. 89% of caregivers are providing care for a family member, a relative of some kind, oftentimes a parent, but maybe an aunt or an uncle. Caregivers, on average, provide about 20, spend about 24 hours a week providing care to folks who don't live with them. But if they do live with them, it's significantly more. And I think that that kind of makes sense. But wow, that's a lot of time that you are devoting, and a lot of love that you are devoting, and a lot of care that you're devoting to this person who you are helping. 75% of caregivers are female, but we know that there are a lot of fellas that are out there providing assistance. It's not unusual for me, maybe for you as well. I often see what looks to me to be a guy and his mother at the grocery store, and he's taking her to grocery shopping and helping her do those types of things. So, you know, this really happens in lots of different ways. And then the average caregiver is about 50 years old or so, maybe, and sometimes older than that. So those are just a few facts about caregivers. So caregivers face an enormous number of challenges, and this is really why we're here. We're going to talk a bit about that. But they've got conflicting demands. Caregivers, care receivers have a lot of needs, right? But your spouse has needs, your children have needs, your employers and your coworkers have needs, and you as a caregiver have your own needs. So trying to meet the needs of everyone inevitably creates conflict and stress. We know that is the case. Ambiguity of roles, something that we're going to talk about knowing your authority, is also a big source of stress and anxiety for caregivers, because sometimes caregivers don't know exactly what their roles and responsibilities are. Let's face it, there aren't very many training courses for caregivers out there, or perhaps you never even occurred to you to take a training course to learn a little bit more about this. Sometimes you get mixed messages about the care receiver and what you're supposed to be doing for them. Maybe it comes from other family members, because the care receiver doesn't necessarily know. The family members don't know as well. You're often thrust into this role that you're not necessarily prepared for, right? You may have been a parent and you've taken care of your kids, but taking care of an adult is a whole different ball game. And then there's just a ton to do, right? There's just so much to do. The workload is a challenge as well. You get conflicting information, um, because you don't necessarily know what to do. You're not trained, and you're facing issues that aren't necessarily consistent with where you are in life, your stage in life. These aren't things that you necessarily need to be thinking about for yourself, but now all of a sudden you have to think about things that are consistent with the care recipient's age or status or situation in life. So you've got all of this new information that you have to try to sift and figure out. And there can be a lot of conflicting information out there, especially if you're trying to Google answers to a lot of these types of things. You could you could feel like a failure, right? There are so many different things to do, and it's so confusing. You're somewhat ill prepared for it. You might feel like a failure, and that also can be a challenge for folks. And so all of these things can add up and together create a variety of negative emotions. Caregivers may, at one time or another, experience feelings of anger, frustration, inadequacy, being overwhelmed, helplessness, resentment, especially for married couples that find themselves in a relationship that is completely changed from the one that they were in to now caregiver and care recipient. And this can cause a lot of stress and anxiety, maybe make the caregiver feel bad, sap their energy, maybe even have cause feelings of low self-esteem. So these challenges are all of the complex challenges, amongst the complex challenges that caregivers are facing. You know, this is why we're here. I mean, this is what we're moved to speak into, this community of caregivers, because we feel like we have something to offer to you, because we feel that we can address the source of some of these challenges. Um, the caregiver and care recipient has many of these challenges, and it gets in the way of the goals that they're both trying to achieve, these challenges. And what often goes unnoticed is that access to legal advice can be beneficial in improving or solving some of these challenges, right? People don't necessarily have access to a lawyer in mind for all of these situations, because they don't always immediately think about calling a lawyer for the challenges that they have in their own lives. And there are a lot of reasons why you don't think about doing that. One of which is you're not exactly sure who to call, right? If you drive down the highway today, you'll see any number of lawyers who would be happy to talk to you if you're involved in an auto accident. But you're not going to see very many lawyers who are going to say, call me if you have a question about whether you are allowed to pass medications to your family member as a caregiver, or whether, what do I do about this reverse mortgage that I just found out that my mom signed and they got a nasty gram in the mail. Those types of things, There's no billboards out there for lawyers begging you to call them to talk to you about those things. So you don't know where to go. And then cost can also be a significant factor as well. You're worried about the cost. How much is it going to cost to get this advice? Unaddressed legal issues are often barriers to things that are really important in the caregiver and care recipient relationship to make that work as well as it can. These unaddressed problems can be barriers to stable housing, so important for the caregiver and the care recipient. Improved finances, making sure that you've got enough to pay for the things that you need to do. Personal or household stability, and then just making better care choices for the care recipient. If those challenges can get resolved, right, it will improve the overall situation for both the caregiver and the recipient. And studies will show that when these issues are addressed, the stress reduces, the anxiety reduces, the feelings of being overwhelmed, helplessness, frustration, all of those get reduced. And the health for both the caregiver and the care recipient ultimately can be improved. You already have, I'll use a big word here, interdisciplinary team in place, right? You already have this team in place for the care recipient: doctor, caregiver, family members, physical therapist, transportation that you have in place. Probably there are some other members of the team that are there to take care of the care recipient, but we are going to suggest to you that it makes sense to have an attorney be part of that team now to help solve some of these challenges, to help reduce and mitigate these challenges. So here's an example of some challenges that you might be facing as a caregiver for either yourself or the care recipient, and some legal interventions that we might do just by way of example, right? Finances. There are a lot of category of challenges relating to finances, right? Here are some ways that an attorney can get involved. Apply for Medicaid, for home care, or for skilled nursing facilities. Do you even know that it's available to help pay for those things? Um, that's what we're here for, to help you with those things. We can help protect assets from nursing homes. We can ensure, in a situation where one spouse is in a facility and the other is still living at home, that the one living at home has enough income and assets to support themselves. We can assist in appealing denials of benefits and help talk about optimizing Social Security benefits. These are some of the things that an elder lawyer, estate planning lawyer, can do to help the situation. Your home, perhaps your most valuable and most important asset. We see a lot of home related issues involving folks that are elderly. We can help secure ownership of the home. We can give advice on loans and reverse mortgages. We can protect the home from accruing government liens, protect eviction. Those types of things are usually very important. Care choices. Wow, what a bewildering topic it is for folks at that stage in their life, to understand what the care options are available to them, and in particular, how they're paid for. And that we can be a big asset for folks in that regard, to understand those options, how they're paid for. Negotiate residency agreements before you sign on the dotted line. Those are big agreements that have a lot of consequences to them, and it's very important to get a lawyer as part of your interdisciplinary team to help you make informed decisions about what you're signing off on there. For caregivers, we can help limit your liability for claims and clarify who has the right to make decisions. Personal or even household stability. Guardianship might fall under this category, where somebody can't care for themselves, can't make their own decisions, and they have not provided for that in the way of powers of attorney or a trust or healthcare directive. Now somebody needs to be put in place as a guardian to help take care of those types of things and stabilize that unstable situation. Identity theft, also a big problem for the elderly. We can get involved in that. Sadly, sometimes restraining orders and protection from abuse orders need to be applied for in the event of abuse. If the elder person is a victim of abuse, we need to get that person away from them. And then sometimes divorce is there as well, where there's a boyfriend or a girlfriend involved that is not necessarily in the best situation for that elderly person. And then finally, estate planning and asset planning. We help with that and prepare and answer questions relating to financial and healthcare powers of attorney. We prepare wills and trusts. We help complete beneficiary forms, and in particular, talk about what it means to put somebody's name on a bank account. That we'll talk a little bit more about that. So this is just a little bit of a snapshot of where we kind of fit into, right, the interdisciplinary team between as it relates to care recipients and caregivers. So let's talk a little bit about the legal fundamentals of caregiving. We're going to switch gears here and talk about this. Um, Here are the things that we'll talk about. Knowing your legal authority, that's going to be a big thing. Caregiving and finances is a category of things that's important to know. Identifying and reporting the wide variety of abuse that sadly our elder community has to deal with. Protecting yourself from claims as a caregiver, and seeking guardianship for the care recipient. We get a lot of calls, a lot of questions about guardianship. So we're going to touch a little bit on that. So before I get going here, I just want to let you know that this is kind of a survey of these issues. We're going to touch upon all of these things, probably not do a deep dive into any of them in particular, but we're going to get the high points on them. And as we, in 2024, looking ahead in 2024, we will definitely offer a series of shorter webinars on each one of these particular issues. So if you have more questions about it, if you want to invite somebody to participate in those, and we encourage you to do that. We will be doing a little bit more of a deep dive and a more of a focus on these particular issues as we go forward. So let's go ahead and dig in. Knowing your legal authority. As a caregiver, this is a big issue. Knowing what your responsibilities are, what your role is. It's very fundamental to the caregiver care recipient relationship. What should you be doing? What do you own, right? As your responsibility for this caregiver. So it's really important for you to understand that. And really at the very base of understanding what your role is making sure that the care recipient has some key legal documents in place that can define the roles and responsibilities of the caregiver, what you are supposed to do and what is not your job. That's also important. Knowing what your role is, but also knowing what your role is not is very important as a caregiver. So if you are in a caregiving situation, I encourage you to ask your loved one, the care recipient, if they have these legal documents um, in place. And one category of financial documents that are used to assist the care recipient in taking care of their finances um, are powers of attorney, right? So, who has authority? That's a big question that you should have. Who has authority over the finances? Is it you or is it someone else? Even if it isn't you, you need to know who it is that pays the bills, who takes care of those types of things. So you want to know about that. And it's important for that person to have the care recipient to have a power of attorney in place. If they don't, it's something that you should suggest that they get in place to make sure there are clear lines of authority over the finances. And that power of attorney also is going to specify the types of things that their agent, that's the person who they nominate, who can handle their finances for them, specific powers that that agent will have and can do certain things. And so the document is very specific about that. If somebody has some type of rights over your bank account, that also can be used to help somebody manage their finances. That could be putting somebody's name on there as a joint account holder. And whenever you do put somebody's name on the joint account, that person is an owner of the money in that account. And this is something we see very often, right? Somebody says, I need help paying my bills. They go to the bank and they put the other person's name on the account. Maybe the bank suggests that is that's the way to do it. Maybe that's the way you think that it should be done. But what you're doing by putting somebody's name on the bank account is you're actually conveying an ownership interest in the money in the account, right? You don't have to go that far. You can just give them check signing authority over your bank account. But keep in mind that if that person's name is on the account, whenever the care recipient passes away, the money in that account is going to belong to that joint account holder, regardless of what the will says or the trust says. So that's something that a lot of folks don't necessarily perceive when they put somebody's name on the bank account. The joint titling on the account, if you're a card player, trumps what is in the will or in the trust or a beneficiary form of some kind. So just keep that in mind. But having those types of things in place is important to making sure that the care recipient has somebody to take care of their finances. Medical decisions also another big role in the caregiver care recipient relationship. And you want to make sure that the care recipient has something in place that details who is going to be able to not only have authority to make medical decisions for them when they're unable to do it, but also have access to medical information. And as a caregiver, it may be really important for you to have access to medical information because you might be the one that is taking them to the doctor. You might be the one who has to make those appointments for them. There's going to be some interplay there for you. So you're going to want to ask your care recipient, do you have a healthcare power of attorney? Right? That healthcare power of attorney says that this person can make medical decisions for me when I am temporarily unable to make those decisions for myself or to communicate them for myself. Maybe it's because they're you know, uh, passed out or they're out of it, or maybe they have have some type of a cognitive problem that they can't make decisions, that they're confused or fuzzy, or maybe have dementia, whatever it is. That's the document that does that. And then a living will is the document that they use that can designate the type of care that they would or would not want whenever they are in an end of life, end stage medical condition at the end of their life, right? Whether they want to be kept alive or just let nature take its course. So very important documents for them to have. They should also have a will or a trust to provide for the orderly uh, conveyance of their assets after they pass away. Um, you know, a Before I talk about that, I want to just suggest to you that a trust, if they have a living trust, sometimes called a revocable living trust or a revocable trust, those are all terms that are interchangeable. That's kind of the ultimate power of attorney, right? It is more powerful than a power of attorney because the assets of the care recipient would be owned by the trust, and the trustee or the successor trustee has control over the assets titled to the trust. So that really is the best way to ensure that a care recipient's assets can be taken care of in the event that they have a disability while they're alive. That's the most power, and it will involve the least amount of delays, the least amount of confusion over legal authority. A power of attorney is also very good to have, but sometimes there can be a bit of a delay whenever you provide that to the financial institution. They may need to validate it first before they will comply with it, or maybe they give you some kind of problem with it. I don't know. But a trust is really the ultimate authority there. But a will or a trust helps people avoid what is called intestate, the law of intestate succession. Whenever you don't have a will or a trust to pass your assets to your loved ones when you pass away, you've waived your right to do that. The government has a will for you, and that's called the law of intestate succession. So the government will substitute its judgment concerning where your money should go for yours because you failed to do it. So now they have to do it. And I don't suggest at all that you would rely upon the government's will to take care of your family. That's just it's a bad decision in almost every instance. But both of these documents provide for an orderly transition of assets to your family members and they also establish authority over the care recipient's assets after they pass away. So super important documents to have. And then I would be remiss if I did not mention beneficiary forms, because a lot of folks have accounts that are going to be controlled by the beneficiary form, especially retirement accounts like an IRA or a 401k. And there are a lot of problems that can arise if beneficiary forms are not completed. So incomplete or dated forms can have negative consequences. They can expose the money in those accounts to government liens. They can also cause those assets to be left to somebody who is eligible for some type of government benefit. And if that person receives the money as a result of a beneficiary designation, it can cause them to be ineligible for benefits until that money is all spent down. And it kind of defeats the purpose of being eligible for those benefits anyway. So it's kind of a hidden trap, right? That people fill it out maybe once in their life and then they forget about it. Things change and they never update them. So super important. If you're the caregiver, this is a good conversation to have or to suggest that a family member has with a care recipient to make sure all of these things are in place. Now, caregiving is going to touch on financial issues for the caregiver too, right? Because caregiving can deal a serious blow to the caregiver's personal finances. Many caregivers say that the cost of caring for an elderly loved one has impacted their own finances, their own ability to plan for the future. So, um, and for the care recipient, it's going to the financial issues that you may have to deal with as a caregiver could be managing their money, making choices for health coverage, understanding Medicare and Medicaid, and how to pay for their care. Money is going to be involved in this relationship, most likely for everybody. So, for the care recipient, understanding the senior care choices that they have is going to be a big money factor that you might have to get involved in. What is home care? What are the differences between personal care, assisted living, skilled nursing, hospice? How are those paid for? What do they cost? How do you plan to make sure that you can afford this coverage? What government benefits are available to help pay for some of this care? And how do you maximize your care recipients' access to government benefits while also protecting their assets to care for perhaps their spouse or to leave a legacy for their families. These are very big, complicated topics that are inevitably come into um, the care recipient's life. And as a caregiver, you may be called upon to deal with these issues. And again, you'd be doing them a favor to suggest that they uh, give some thought to some of these things. But for the caregiver, your personal finances could be impacted as well. So we suggest that if you're going to be a caregiver, getting a personal budget in place is a pretty good idea for you. It puts you in control of the money that you have coming in and where it goes, and it helps you avoid financial problems by planning in advance to save some money to cover some unexpected expenses, and increases the chances that you'll be able to meet your money goals and have some financial peace. So getting a personal budget in place is a really good idea for you. We have an additional resource available to you. It's a program called Money Canvas. It's offered by Thrivent Financial. It is a free money coaching program that you can do. It's a one-on-one money coaching program to help you get a grip on your finances and put a budget together so that you can meet your expenses. Again, it's 100% totally free, no nothing attached. And we'll provide some links to that program for you. Um, but for the caregiver, you got to get your own key documents in place too. So if you're going to suggest that the care recipient, how important it is for them to get those documents in place, one way to model that is to live it out yourself and get these documents in place for yourself so that you're taken care of, your family is taken care of as well. This is a great place to start if you want to get your estate planning, your will started. If you're in Pennsylvania, we invite you to go to our website. You can download our will questionnaire and get the process started. You can fill it out electronically and send it to us to get things going. And we have a lot of other information available on our website if you have questions about estate planning, powers of attorney, digital asset planning, those types of things. So lots of good information on our website. So for the working caregiver, many caregivers are actually working. It's also important for you to understand your rights as an employee to care for a family member because you can take time off in many instances for that. The main law that you would have to be aware of is the Family and Medical Leave Act. The FMLA is what we call it, provides eligible employees with the ability to use job protected leave to care for a family member. Very often, a parent, a spouse, or a child, but in some instances, it can be extended beyond that for the family. Um, the FMLA applies to employers that have 50 or more employees, right? And it's a public company, not a private company or a nonprofit. You have to have worked for at least 12 months, have a certain number of hours that you've worked during that 12-month period of time. And if you meet those qualifications, you're eligible to take up to 12 work weeks of leave in any 12-month period of time to care for a loved one that has a serious medical condition. And that's a loaded term. We can help you understand what that means and if your loved one fits that category that would allow you to take leave. And that leave doesn't have to be 12 solid months. FMLA would allow you to take time off in the form of a reduced schedule, which can kind of extend that period of time literally longer over a period of 12 months. It might also allow you to take intermittent leave. And so instead of 12 straight weeks, you can take 2 days this week, 3 days next week, 2 days the following week, and so on and so forth. So it allows for intermittent leave as well. And some states have their own family or medical leave laws that might provide benefits in excess of FMLA, or maybe they would apply to employers that have less than 50 employees. So it's important to be able to have a lawyer that you can talk to about your rights. If you are working and if you do need to take time off, perhaps it's the result of a sudden health event for a family member and you're called upon to take care of them, we can help you understand what your rights are as a working caregiver to take time off to care for your family member. Another topic that touches on finances and caregiving are family caregiver agreements, right? Can you get paid as a family caregiver? And of course, the answer is yes, and it's entirely appropriate for you to be paid as a caregiver. It might be that you get paid by the care recipient out of their pocket, right? They might do that for you. And if the care recipient has resources such that they're eligible for some medical assistance programs, the state will actually pay you as a caregiver for the care that you're providing in the home for your family member. And there are a lot of reasons why it's reasonable to be paid as a caregiver or be compensated. You don't have to just do it because this is a loved one out of the goodness of your heart, but oftentimes caregivers reduce their income to provide care, or maybe they even quit their jobs entirely to devote themselves full time to caring for a family member. They're going to ultimately have reduced Social Security benefits because they're not paying into the system, and have reduced retirement benefits because they're not paying into a retirement program, and perhaps they even lose healthcare coverage. So there are a lot of reasons why it makes sense for a caregiver to get paid, to get compensated in some way for the care that they're providing. Perhaps the care recipient moves into your home and you've got additional expenses. Again, it's entirely appropriate and 100% legal for the caregiver to receive compensation for any number of these things. But I will say it, but first, it's really, really important to have proper arrangements put in place because there are negative consequences to just getting paid and not having the appropriate arrangements in place. Very important for you to have a written agreement that spells out a variety of terms relating to that caregiver relationship. Um, so it might, um, it's going to cover a variety of things, but if there's no written agreement in place, it's very likely, at least under Pennsylvania law and maybe in other states as well, that that money being given from the care recipient to the caregiver is presumed to be a gift, right? And not compensation for services rendered. And if that care recipient later applies for some type of medical assistance benefits of some kind for nursing care or otherwise, the payments that were made to the caregiver without an express agreement could be treated as gifts and render that care recipient ineligible for medical assistance benefits for some period of time to provide for skilled nursing care or some other very important benefits. And the average cost of skilled nursing in Pennsylvania right now is about $14,000 a month. So that can be a very serious penalty that you don't want to have happen. And this is an easy mistake to make, but it's also an easy mistake to avoid by getting a caregiver agreement in place in advance. Sometimes these agreements are called personal services agreement, and they typically address a variety of terms such as accommodations. Maybe the person is living with you, what meals, what type of care you're providing, financial management, if you're doing that, cleaning, laundry, transportation, all of the various things that you're doing for this person should be in the agreement. And then the amount of money that you're going to be paid is going to be a figure that we have to make sure that's not in excess of what would be reasonable under the circumstances. Kevin, do you have a sort of a back of the envelope figure that you would say is deemed reasonable these days in Pennsylvania?
Now, basically, they're deeming $25 an hour to be a reasonable amount that a caregiver can receive without getting issues with the department.
Yeah. And so that's a number. They don't publish a number out that says this is what we're going to approve. It's really kind of based on experience. If you're uh, interacting with the state for applications for medical assistance benefits for home care or long-term care, you kind of have to know, what they're allowing out there. So that's kind of where we are. Now, if you're going to be in a caregiver relationship and you've got a caregiver agreement, a couple of practical tips that we would leave with you is that you should maintain some type of a diary of the hours that you've spent caring for the loved one and a description of the work that you're doing. Just in case there's an application for benefits and there's a question that arises about what it is that you're doing for the money that you're being paid. It's a really good idea for you to have a diary that makes it a whole lot easier to justify the payments to you as compensation rather than as gifts. So just a good thing that we would suggest that you do. I'm sure that if Kevin were working with you on your loved one's application for benefits and that question arose, if you had a detailed diary, he would just absolutely love you for providing that to him. It would make his job a whole lot easier. And then secondly, you should document, get some information from doctors or healthcare providers of some kind that justify the need or corroborating the need for a caregiver, right? If the doctor says this person can't care for themselves or it's unsafe for them to live by themselves, or they need somebody to come in, that also really helps to justify that this is an actual bona fide caregiving relationship where there's a need, there are services being provided, and that the compensation is reasonable and appropriate. All right. So, this is a very sad topic. Unfortunately, we see this happen all the time, but it's just so important for caregivers to identify and report elder abuse and neglect. Caregivers are really in a great position to identify these instances and can really have a big impact on mitigating or even ending these types of instances. Here are just a few examples of abuse or exploitation that we see. And sadly, I think these stories come into our office every day where something like this has happened, where we've got a transfer of assets out of accounts, perhaps to a girlfriend or to a family member. And, these can have serious consequences, not only for the loss of the money for the elderly person, but again, in the event they're applying for some type of benefits, that transfer may render them ineligible for benefits for a period of time. So it's kind of a double whammy for them. The 20,000 is going out of their account, and they're paying $20,000 for care that otherwise the government would have paid for as well. So it can be a really serious financial situation for the family. A couple of others here where our family caregiver said that her mother was receiving threatening letters from her longtime friend and handyman who says, "I'm not going to help you anymore and provide you assistance unless you pay me more money." And oftentimes, elderly folks value those relationships, or they're afraid that those relationships will end. And it's really, they're in a difficult position to say no because they have that need, and there's nobody else out there to provide them. So sometimes these abusers really take advantage of a person at a time that they're absolutely weakest, where the power imbalance is the greatest to avail themselves of somebody's money. Very sad situations that are out there. So we have a variety of abuse that our elderly uh, uh, family members sometimes have to deal with. Physical abuse, of course, um, causing bodily harm to an at-risk elder, physical pain or bruising. Perhaps there's unreasonable confinement. Um, there are a variety of indicators like repeated visits to the emergency room, bruises or injuries in various stages of healing, unconvincing explanations by somebody in their life about how these injuries happened. And they often happen to an elder that's isolated from family and friends or medical care. Um, you know, you may be as a caregiver, especially if somebody is in a facility of some kind, you may see these things and wonder how they happen. Not all bruising is nefarious, right? And it may be just something that you need to ask more questions about, and there may be a perfectly reasonable explanation for them, especially if they're in a facility. But sometimes it does happen in a facility, or sometimes you're paying a visit to a family member and you see these things. It's just something to be looking for that should cause additional inquiry for you. Neglect is just another form of elder abuse with malnutrition, dehydration, untreated physical conditions. Many of these things are the things that cause a care recipient relationship to begin with anyway, because the family member can't feed themselves right, can't bathe themselves, can't treat their own conditions. But these can also happen when somebody is providing care for them or when they're living for them. So you just have to be wary of these types of things um, as well, and identify them and ask questions, and perhaps need to report them. Exploitation is one we probably see the most, where an elder's money or other assets are taken from them against their will or without their knowledge. They may also be deceived or harassed or intimidated um, by somebody to get them to do something that is either against their will or not in their best interests. Signs of exploitation, and I've been involved in many court cases involving instances of exploitation like this, often by a family member. It's almost always by a family member, almost always by a family member who's also the caregiver in many instances. And, the telltale signs are deviation from long held financial habits. So frequently you have the story that I'm told by the family that is concerned about these things happening is dad was always very frugal. He was always a saver, never spent any money. And yet in the year or two after sister or cousin started taking care of him, he bought her a car and money started disappearing from the bank account. Perhaps the will's been changed. The really sophisticated thieves actually don't bother with the will. They actually change beneficiary forms or they retitle assets to themselves. Um, Folks expect a will to be changed, but you know that's not often the best way to do it. Thieves are a little bit crafty. They know how to do that. Put their names on accounts. Um, you might see an elder that runs up some unpaid bills, right? Especially they've stopped paying their real estate taxes. They're getting unpaid utilities get shut off, unpaid notices in the mail. Collectors are calling, those types of things. Checks made to cash. That's a red flag to see those types of things. Personal belongings are missing. These are all different forms of exploitation that really should scream out to you that there's some kind of problem going on here. And the abusers and exploiters have a lot of very similar characteristics, right? They react inappropriately in situations with the elder. I think you know it when you see it. Sense of entitlement. Might have a sense of entitlement because they're taking care of the elder, and so they're entitled to the money. They might not say it like that, but I think they probably have a sense of that. Um, Perhaps they have an unrealistic expectations of the elder, blames the elder for not doing things that they're clearly not capable of doing or they can't control, getting mad at an elder who soils themselves, but they can't control their bowels, sort of a thing, and they're abusive or let them sit in that for extended periods of time. When questioned, these abusers often relate contradictory history or partial histories, things that just don't add up, or they just get angry about your asking and say, "How dare you accuse me?" or "I can't believe that you would accuse me of that," to try to deflect having to answer questions about it. Also, very, very common. Perhaps they have a history of abuse or exploiting somebody else in the past. And sometimes families know about these things that that person took care of their aunt before too and did all of the same things with that person as well. So they fall into these categories. They all seem to have a very similar profile about them. So if you think something like this is going on, I encourage you to ask questions. Sometimes asking questions can help confirm what's going on there, the way the person reacts to the questions that are being asked. um, if there's a lawyer involved for the care recipient, might be a good person to talk to about it, or talk to your own lawyer about it before you report, to ask some questions about it. There might be some explanations that will change your mind, but if reporting is the appropriate thing to do, there are a variety of places that you can report these things to. At least in Pennsylvania, there's a Pennsylvania Department of Aging. I'm sure that there's a Department of Aging in every state, wherever it is that you're viewing this webinar from. I'm sure that your state has one of those. Your county will have some type of an area agency on aging that you can report it to. Law enforcement can also be appropriate, especially in the event of imminent physical risk or actual injury. And at least in Pennsylvania, there's a senior law center that can provide some free legal advice and maybe even representation for older adults who qualify to stop abusive situations from happening. And perhaps they need to file a petition for protection from abuse to keep a family member or a significant other, to get them out of the house, get them away from the situation, so that they're not allowed to be around the elder anymore. Sometimes that's an appropriate thing to do. Okay, we're just about at 1 o'clock, so I'm gonna hustle through these things. Let's All right, protecting yourself from claims and accusations. you know as a caregiver, you are taking on a little bit of a risk there, that you can be accused of something. And oftentimes these accusations arise out of conflicts of care, accusations about finances, self-dealing, undue influence. If your name appears on a bank account for somebody may suggest that that's a problem. Maybe there's a conflicts about the access to the care recipient or with family members. And these can have significant consequences for the care recipient, right? Um, they might be ineligible for benefits of some kind. For you, you may be ineligible as a caregiver to receive support payments for caring for this person, and it can expose you to lawsuits, which can be very expensive for you to pay if you're dealing with these types of accusations. Sometimes they come up after the care recipient has passed away, and somebody discovers that money's missing and they don't know why. Sometimes these accusations arise out of a lack of answers or lack of understanding about what had happened, even though what you did was entirely appropriate, and can even result in some criminal responsibility as well. So again, it puts a premium on gathering important documents to make sure that you know what your role is. Power of attorney. If you are assisting somebody as the agent under a power of attorney, that gives you a certain level of defensibility, authority over what you're doing. Healthcare directives. Um, I highly recommend that if you're going to start helping a care recipient with their finances, that before you start doing anything, that you make an inventory of their financial accounts and balances so that you have a snapshot of what's there before you start assisting them with their finances. Whatever it is that you're doing for them, even if all it is that you're doing is you're writing out checks and then you have them sign them, that is still helping them with their finances. Somebody's going to know that the handwriting on that check is yours and not theirs. And they might not even, people, believe me, if they want to find some type of suspicion, they will find it even in that situation. So creating an inventory is in a snapshot is really helpful so that this is what was there whenever I started helping so and so with their finances. And you might even want to create an inventory of the care recipient's online accounts and access information, especially if you're going to have to be able to get into those in order to assist them with their finances. A lot of do's and don'ts. I'm going to send these out. These will be part of the follow-on materials that we send to you. But if you're going to be engaging in financial management, there are some do's and don'ts, some practical tips that we would have for you that you should definitely engage in, and also some don'ts that you're going to want to avoid doing. Withdrawing cash from their account and paying things with cash, usually a bad idea. You need a record. You want some type of a money trail. You don't want to use their debit card or credit cards for personal expenses. I don't suggest that you do that ever. Um, it'd be better for them to pay you as a caregiver under a legitimate caregiver agreement, and then you can pay for those things, or there's be some type of reimbursement if you've got receipts of some kind. Don't add your own name to the care recipient's financial accounts, or at least without consulting with an attorney, and make sure that there are good ways to do that and there are not so good ways to do that. Adding your own name to their property, making yourself a beneficiary on their accounts, those all come with certain risks. Um, Combining your own money with money of the care recipient, oftentimes a bad idea, almost always a bad idea. And um, don't provide money or property to yourself or relatives without the consent of the care recipient if they're able to communicate with you about that. Guardianship is also a question that we get a lot, right? As people grow older, sometimes they are unable to care for themselves because of a physical or a cognitive disability. And a guardianship is something that's appropriate. And guardianships typically will come up whenever the care recipient does not have a financial power of attorney or a health care power of attorney or a trust of some kind. That you're in complete control as the care recipient whenever you have those in place to dictate who can provide care for you. But whenever you have not done those things, a guardianship may be necessary. And a guardian is a person, sometimes an agency of some kind that the court appoints to be responsible for the affairs of the person who is incapacitated, right? And they can also be appointed to care for minor children who have disabilities as well. When does somebody need a guardian? Whenever they're incapable of making their own decisions. Perhaps it's because of an illness or a cognitive disability. And a probate court or the orphans court or some similar court in your state, wherever it is that you are, must find that the person is incapable of managing their affairs. There has to be a finding by the court based on evidence before a guardian can be appointed. So, who can be a guardian? A guardian. Just about everybody in Pennsylvania can be a guardian. And just because you have a familiar relationship with somebody doesn't prevent you from being appointed by the court to be a guardian in most instances. Sometimes the court will appoint a county agency or some type of a nonprofit organization as well. It just really depends on how the situation comes to the court. And I'm going through this stuff a little quickly, but I'm happy to answer any follow-up questions offline. So what's the process for appointing a guardian? In all cases, a legal document called a petition has to be filed with the probate court, and that petition has to list or state the reasons why you believe, the petitioner, believe that a guardian should be appointed for your loved one. And in most cases, those statements in the petition have to be supported by a written medical report or testimony from a doctor or other medical provider, and some evidence that who believes that the guardianship should be ordered, that this person needs to have a guardian appointed for them. So what's the process? It really depends on whether it's an emergency or a non-emergency situation. But in an emergency situation, where a sudden onset of some health event necessitates this, and there's nobody else to care for them, the court can issue a temporary guardianship. It typically involves a situation where there's some terrible harm that's going to occur in the very, very short term in the event a guardian isn't appointed, right? And usually the court will appoint this temporary guardian for about 72 hours, but that can be extended if the emergency, the situation of the emergency is extended. But in non-emergency situations, when the petition is filed, the court will set a hearing date. The petition has to be given to the person who's alleged to be incapacitated. They have a chance to read it, or it'll be read to them. Other persons who have an interest in the matter also will receive notice, like maybe the other kids, if this is a parent. And those persons will be given an opportunity to respond to the allegations in the petition. The hearing will take place where proponents of the guardianship and opponents of the guardianship will have an opportunity to present testimony and evidence. And these hearings can be traumatic, right? Because you're suggesting to someone to take their rights away from them, to control their own affairs. And that can be a very difficult situation for somebody to come to file this petition for a parent who is slipping, whose capabilities are really declining, and they may think that they can take care of themselves, but you know that they can't, and they're just in the state of denial. Or perhaps they are in the process of being exploited or taken advantage of by somebody else, and you want to stop this by getting a guardian in place to take control of the assets, make the medical decisions, and keep the bad people away. Sometimes that's the situation that arises as well. So I know I covered a lot of that stuff very quickly, and I apologize for that. If you are interested, we have a ton of other information available to you. We have a YouTube channel